Okay, let's go to resignation. This is a mode of terminating employer-employee relationship at the instance of the employee. Since there could be no perpetual employment, the employee cannot be compelled to be rendering service until death, because this is contrary to the constitutional mandate of involuntary servitude. Then the employee can resign. We are talking here of Article 300 of the Labor Code. There are two grounds by which the employee may resign. The first ground is without any cause at all. The employer or employee can sever the employer-employee relationship by serving a written notice on the employer at least 1 month in advance prior to effectivity of resignation. The employer under this case or under this paragraph, upon whom no such notice was served, may hold the employee liable for damages. We are talking here of actual damage that the employer may suffer because of sudden resignation of the employee. Under paragraph B, however, the employee may put an end to employment or employer-employee relationship without the 30-day notice to the employer because the employee suffered serious insult by the employer or his representative, or when the employee suffered inhumane and unbearable treatment done by the employer or his authorized representative, or there is commission of a crime or offense by the employer or his authorized representative against the person of the employee or any of the immediate members of his family, and other analogous or causes analogous to any of the foregoing. So in this case, there is no need to serve written notice and no need for an approval by the employer. Let's start with the first ground. There are things that you must remember. Since this is a unilateral act of the employee, then the employee can sever employer-employee relationship by serving the written notice, 30 days or 1 month. If the employee will not observe this 1 month notice, the employee may be held liable for actual damage suffered by the employer. Now, the next question is, when is the resignation voluntarily done by the employee considered effective? The rule is, it is considered effective upon approval or acceptance and approval by the employer. From that day onward, there is already severance of employer-employee relationship. What is the significance of this approval? It means that prior to approval, the employee can withdraw the resignation letter and continue employment. Should the employee change his or her mind after approval, the employee is deemed terminated already and cannot go back to work. Otherwise, the employee will compete with the new applicants for the same position. The next question now is, if the employee tendered voluntary resignation, is the employee entitled to separation pay? The answer is no, because it is voluntary on his part. There is no obligation on the part of the employer to give separation pay, except there is a company policy, or there is a practice, or there is a CBA. But those are the exceptions. We are talking here of voluntary resignation. Now let's go to the second type of resignation under second paragraph, where the employee was forced to resign because of the following factors which we enumerated. In this case, this would give rise to constructive dismissal. So therefore, if you will be asked, can an employee who tendered resignation file an illegal dismissal case? Yes, if the evidence would show that the execution of resignation was involuntarily done because of the circumstances enumerated under the second paragraph, then that will be constructive dismissal, and the employer will be liable to pay separation pay. So in this case, under second paragraph, since there is no need for approval, so from the time the employer received the resignation letter, it is deemed approved because no need of approval is required. Otherwise, the employee will be compelled to work with the employer against his or her will. Just take note that if you file an illegal dismissal case based on constructive dismissal, alleging that the resignation was involuntarily executed, do not ask for reinstatement, because the filing of this case presupposes that the atmosphere has become unbearable, uncomfortable, unreasonable, discriminatory on the part of the employee. How do we determine the voluntariness of the execution of resignation letter? The jurisprudence of the Supreme Court will tell you that you have to look at the acts prior to execution and immediately thereafter. We have to put all the facts together and make the conclusion and make a legal conclusion on whether or not the resignation was validly executed. For example, if the employee has sent so many letters requesting for payment of whatever unpaid benefits with the clear intention to resign, then that is considered voluntary on the part of the employee. Assuming there is one case, assuming that during the pendency of the illegal dismissal case, where the employee found employment, the employer argued that the employee has already resigned because of the employment by which the employee was hired. According to Supreme Court, it is not acceptable. The argument is not acceptable. Why? It should be expected, according to the court, that the employee cannot wait for the outcome of the case. It has to find employment while the litigation is still pending. You cannot fault the employee to find employment for their economic survival. However, if the employee who resigned executes or executed a quit claim, then he will be or she will be stopped from filing any further money claims against the employer arising from employment. However, such money claims may be given due course only when the voluntariness of the execution of quit claim or release is put in issue, or when it is established that there is written agreement between the employer and the employee which would entitle the employee to other remuneration or benefits upon his or her resignation. Okay, those are the things that you must remember when it comes to resignation.